the state outside the presence of the jury. First of all, we just had a break between the state and defense. It was just to allow the defense to prepare for the closing argument. And then the next bench conference was just to talk with the attorneys about the timing of the state's rebuttal, and wanted to ensure both sides would have no issue breaking for the evening. As discussed with both sides, it was the court's preference to break for a couple of reasons. The jury would need a break, number one, and number two, in the interest of preserving the jury, to ensure we had no issues with any jurors getting sick overnight after it was turned over to the jury, and to ensure that we had a full panel when it is ultimately submitted to the jury. Is that a fair summary, Mr. Larson?
Yes, Your Honor.
And Mr. Puentes?
It is, Your Honor.
All right, thank you. Are you ready to proceed then, Mr. Larson?
Yes, Your Honor.
All right, we'll bring the jury in. Good morning, ladies and gentlemen. Is the state ready to proceed with its rebuttal?
It is, Your Honor.
You may proceed.
May it please the court, counsel, members of the jury, again. This is our chance to offer what's called a rebuttal argument. You heard our closing argument yesterday, as well as Mr. Puentes' argument. This is our chance to essentially respond to that. Mr. Puentes talked for over an hour yesterday. I'm not going to go through point by point or anything like that. I trust that you'll use your reason and common sense when evaluating the arguments that were made. I do want to go over a couple different, or hit a couple of highlights that I want to make sure I do that before you go deliberate. Starting off with the processing of the charges. Mr. Puentes talked about working in the gray, is how he described it, or something to that effect. And kind of told you what charges he thought did or didn't apply, and kind of told you don't even need to worry about those. That's not what the instructions tell you. The instructions are not gray, they're black and white. You start with murder in the first degree, and the only way you consider any of the other charges is if you deliberate and find that he's not guilty of those. Then you move on to murder in the second degree. And the only way you move off of murder second degree is, again, if you find the defendant not guilty of that charge. The good news is, as I argued yesterday, the state has proved its case beyond a reasonable doubt for murder in the first degree, and the state does not anticipate that you'll need to go any farther than that when going through those charges. They also talked about count 2, the domestic abuse assault with intent to inflict serious injury. And Mr. Puentes, I think, categorized that charge as, I think he said it was factually inconsistent. That's not a phrase you're going to find anywhere in the instructions. And essentially, the defense is asking you, don't consider that charge. You don't need to worry about that because it's, quote, factually inconsistent. That's not your duty as jurors. Your duty as jurors is to evaluate each charge on its merits. It is a separate charge. It is worthy of your consideration. It's also worth noting that when talking about count 2, the defense made no argument that the defendant's not guilty of that charge in any way, shape, or form. Because as you go through those elements of count 2, as well as count 1, you're going to find evidence to establish the defendant's guilt beyond a reasonable doubt. I want to talk about premeditation. Mr. Puente spent a fair amount of time talking about that yesterday, essentially arguing that this was a reflexive act and that there was no time to premeditate. He actually compared beating and stabbing your girlfriend to death, essentially akin to riding a bike or eating a meal. Even if you were inclined to believe that a single strike or single blow would be akin to that, a reflexive action, there were 40 to 50, somewhere in that neighborhood, different acts that resulted in this crime. This is not a reflexive act. It's not riding a bike where you don't have to think, pedal my right leg, pedal my left leg. This is 40 to 50 different strikes, 40 to 50 different decisions. And that's not even considering the fact that he changed weapons at least twice. So again, using the defense theory that this was like riding a bike, this would be the same as getting off your bike and getting on a different one, or getting off your bike and getting on a motorized scooter. That's not a reflexive act. That takes deliberation, it takes consideration. That's a decision that the defendant would have had to have made while committing this crime. He also took issue with the fact that there was no evidence. There was no Google searches. There was no text messages showing that the defendant was planning to do this. Again, the state's not required to prove that. Essentially, that would be evidence that the defendant made a good plan. And the state's not arguing that the defendant made a good plan, nor do we have to prove that there was really a plan at all, other than the fact to prove that there was premeditation and deliberation. The judge told you that to premeditate means to think and ponder before acting. That's all we're required to prove. That does not have to exist for any particular length of time. It can be an instant, it can be a second. It can certainly happen in the time that this crime would have had to have taken to complete. And again, even taking the defendant's statement that he stabbed Taylor to put her out of her misery after he saw how injured she was, that in and of itself is sufficient premeditation and specific intent to kill in order to convict the defendant of murder in the first degree. Every time he switched weapons, he made a choice. Every time he stabbed Taylor, he made a choice. Every time he beat her with a bat, he made a choice. This case is full of choices. It's full of deliberation. It's full of premeditation. I want to talk about the specific story that Mr. Puentes told you that he believed the facts bore out. He told you that he believes Taylor was struck one time, she fell, broke her mandible or jaw, and that everything else happened after she died. All of the stab wounds happened after she died. All of the bat strikes happened after she died. Again, with the exception of one, whether that was a bat or a fist or whatever. They do concede he hit her at least once. Again, the judge told you to use your reason and common sense when evaluating the evidence. Did that version of events, did that story, did that make sense based on the evidence you've seen in this case? It doesn't. What story does make sense? The story, or what the defendant told Detective Rowling after he came clean and said, oh, the first story, I made all that up. After that point, what the defendant told you was what happened. That story matches up with the physical evidence that we see on scene. Again, I'm not going to go through every piece of physical evidence that doesn't corroborate the version that Mr. Puentes told you. But if the defendant killed Taylor in the kitchen, as Mr. Puentes told you that he did, and then drug her to the front door, first question you should have is why would he drag her to the front door? There's no reason to do that. Certainly nothing on the record that indicates why he would have done that. But even taking that part out, we would see a blood trail from the kitchen to the front door. We don't see that. We see a pool of blood just outside of the kitchen, but there's certainly no trail going from one spot to the other. We'd also expect to see maybe that pool of blood have some drag marks in it from getting a foot drugged through as she was being drugged through the apartment. Doesn't make sense. There's no physical evidence of that we see on scene. Well, maybe the defendant carried her. Maybe he didn't have to drag her. Maybe he carried her. What would we see then? We'd see blood all over his arms. We'd see blood on his torso. We don't see that either. Why don't we see that? Because that's not what happened. The fact of the matter is, the defendant beat Taylor over multiple areas of the apartment and then killed her by the front door as she was trying to leave, more than likely. I'd also ask you this. Who's in a better position to tell you what happened? Mr. Puentes, who wasn't there, or the defendant who was? The defendant was there. The defendant knows what happened. The defendant told us what happened, or at least told Detective Rowling, and you heard that interview. He told Detective Rowling what happened, again, after he came clean that first time. Now, 1 year later, we hear the defendant testify. He testified yesterday that he has no recollection of what happened. He did concede that when he talked to Detective Rowling, at that time he did have some memory of what happened, but today he doesn't. Or yesterday he didn't. Does that strike you as something that you would forget over the course of a year, beating and stabbing your girlfriend to death? Or does it strike you as something that the defendant does not want to remember, or does not want to admit remembering, so that he doesn't have to take responsibility for what he did? Again, I ask you to find the defendant guilty of count 1, murder in the first degree, and count 2, domestic abuse assault with intent to inflict serious injury. Thank you.
Ladies and gentlemen, at this time, I will read to you the remainder of the jury instructions. You may not communicate about instruction number 41. You may not communicate about this case before reaching your verdict. This includes via cell phone and electronic media such as text messages, email, electronic messaging, applications, and any social media platform, including but not limited to Facebook, LinkedIn, YouTube, Twitter, TikTok, Instagram, Snapchat, and any other social media applications you may use. Do not do any research or make any investigation about this case on your own. Do not visit or view any place discussed in this case, and do not use internet or application-based maps or programs or any other application, program, or device to search for or view any place discussed in the testimony. Also, do not research any information about this case, the law, or the people involved, including the parties, the witnesses, the lawyers, or the judge. This includes using the internet to research events or people referenced in the trial. This case will be tried on the evidence presented in the courtroom. If you conduct independent research, you will be relying on matters not presented in court. The parties have a right to have this case decided on the evidence they know about and that has been introduced here in court. If you do some research or investigation or experiment that we do not know about, then your verdict may be influenced by inaccurate, incomplete, or misleading information that has not been tested by the trial process, including the oath to tell the truth and by cross-examination. All of the parties are entitled to a fair trial rendered by an impartial jury. You must conduct yourself so as to maintain the integrity of the trial process. If you decide a case based on information not presented in court, you will have denied the parties a fair trial in accordance with the rules of the state, and you will have done an injustice. It is very important that you abide by these rules. Failure to follow these instructions may result in the case having to be retried and could result in you being held in contempt and punished. It is important that we have your full and undivided attention during the trial. Instruction number 42. When you begin your deliberations, you should select a foreperson. He or she shall see that your deliberations are carried on in an orderly manner, that the issues are fully and freely discussed, and that every juror is given an opportunity to express his or her views. In order to return a verdict, each juror must agree to it. Your verdict must be unanimous. It is your duty as jurors to consult with one another and reach an agreement if you can do so without compromising your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with the other jurors. During your deliberations, do not hesitate to re-examine your view and change your opinion if convinced it is wrong. But do not change your opinion as to the weight or effect of the evidence just because it is the opinion of the other jurors, or for the mere purpose of returning a verdict. Remember, you are the judges of the facts. Your sole duty is to find the truth and do justice. Instruction number 43. During the trial, you've been allowed to take notes. You may take these with you to the jury room to use in your deliberations. Remember, these are notes and not evidence. Generally, they reflect the recollection or impressions of the evidence as viewed by the person taking them and may be inaccurate or incomplete. Upon reaching a verdict, leave the notes in the jury room and they will be destroyed. Instruction number 44. Occasionally, after a jury retires to the jury room, the members have questions. I have prepared the instructions after carefully considering this case with the lawyers and defendant. I have tried to use language which is generally understandable. Usually, questions about instructions can be answered by carefully rereading the instructions. If, however, any of you feel it is necessary to ask a question, you must do so in writing and deliver the question to the court attendant. I cannot communicate with you without first discussing your question and the potential answer with the lawyers and defendant. This process naturally takes time and deliberation before I can reply. If there is a question submitted, the foreperson shall read my response to the jury, keep any written question and my response, and return it to the court with the verdict. The court attendant who has been working with me on this case is in the same position as I am. Please do not put her on the spot by asking her any questions. You should direct any questions to the court and not to the court attendant. Instruction number 45. I am giving you 5 verdict forms under count 1 and 5 verdict forms under count 2. You will only sign 1 verdict form for each count. When you have agreed upon a verdict and the foreperson has signed the verdict forms, please notify the court attendant. Dated this 11th day of March, 2025, Henry W. Latham II, District Court Judge, 7th Judicial District of Iowa. Do you solemnly swear or affirm that you will keep take and keep this jury together in a safe and convenient place until they have agreed upon a verdict and are discharged by the court, and that you will not allow any person to speak with or communicate with them, nor will you make any communication with them yourself during their deliberations, except to ask if they have agreed upon a verdict, unless by order of the court, that you will not communicate the state of their deliberation, not the verdict agreed upon, until the same has been rendered in court, and that the exhibits taken by you and delivered by the jury shall not be left unattended or tampered with until returned to the court. If so, please answer, I do.
I do.
At this time, I'm going to release the alternate jurors at this time. I would ask that you not discuss this case until you receive a phone call from my court attendant that the jury has reached a verdict. And those alternates are jurors number 49 and 51. I thank you for your service. And if you wait in the hallway after the jury retires, then my court attendant will take your phone number. Thank you.
All rise for the jury.
The defendant is present along with his counsel and counsel for the state. I'd like to make a record on a couple matters. It's the common practice of this county to provide a laptop that only has an application to allow the jury to view the electronic exhibits at their leisure. That laptop does not have the capability of connecting to the internet or using any other applications on that laptop. The laptop is provided by the state, and Mr. Larson, do we have that laptop available?
Your Honor, I provided that laptop to the court attendant yesterday.
Okay.
I spoke with Mr. Puentes informally. It's my understanding there's not an objection to that. And they also have a CD-ROM or DVD-ROM, I'm not sure what the term would be, to view the electronic exhibit. So there are no exhibits on the computer itself, but they'd have to use the external drive to view those exhibits.
All right. And Mr. Puentes, is there any issue with that laptop going back to the jury?
There's not any issue, Your Honor. We were given effectively two options. They had prepared one computer that I think was embedded with the exhibits and one where it was stripped bare with an external CD-ROM. After discussing it, it was decided that we would use a stripped-down version, which is what's being offered with a external CD-ROM. So with respect to that, we have no objection.
And I prefer that as well. Thank you very much. And then the next item that I'd like to discuss, we do have a knife and the baseball bat. Are there any issues with those exhibits going back to the jury?
Not on behalf of the state, Your Honor.
No.
All right, thank you. We'll be in adjournment. It is my understanding the jury has reached a verdict. Before the jury comes in, I would ask that everyone in the courtroom maintain the decorum of the courtroom. It's very important. It would be very disrespectful to the jury if there is any outbursts. And to be quite honest, I will not tolerate it out of respect for the jury's decision. We'll let the jury come in.
All rise, jury entering.
You may be seated. I understand the jury has reached a verdict. If you would please hand that to my court attendant. We, the jury, find the defendant guilty of murder in the first degree. We, the jury, find the defendant guilty of domestic abuse, assault with the intent to inflict serious injury. Ladies and gentlemen, thank you for your service as jurors. I would assume the defense would like the jury polled. Ladies and gentlemen, what this is that my court attendant will read a question. She will ask for your response to determine if this is indeed your verdict of each of you. I will ask that she identify each of you by number. It would only be 1 through 12, and we will start here in the upper left-hand corner of the jury box, proceed across, and then go to the second row.
Juror number 1, is this and was this your verdict?
Yes.
Juror number 2,
Yes.
juror number 3,
Yes.
juror number 4,
Yes.
juror number 5,
Yes.
juror number 6,
Yes.
juror number 7,
Yes.
juror number 8,
Yes.
juror number 9,
Yes.
juror number 10,
Yes.
juror number 11,
Yes.
juror number 12.
Yes.
Thank you, ladies and gentlemen. This will conclude your service. I'd ask that you return to the jury room, and I'll be with you shortly. Thank you.
All rise for the jury.
You may be seated. At this time, as the defendant has been found guilty of murder in the first degree, bond will be revoked at this time, and he will remain in custody pending sentencing. And Mr. Prentice, do you wish to address the court?
If I may briefly, Your Honor,
You may.
and this will not be an extensive record, but I do want to inform the court, my client is requesting immediate sentencing, particularly in light of the verdicts that were just heard by this courtroom. It's a non-discretionary sentencing situation, and I can make a more extensive record if necessary with respect to a colloquy, but certainly only in the event that the court's going to grant that request.
Thank you. State?
Your Honor, the state resists that request. I've spoken to several family members shortly before coming up to hear the verdict read. I know of at least 2 family members that wish to make a victim impact statement. I anticipate there may be more than that as well. In any event, the family members I spoke to are not prepared to provide a statement right at this moment and would request additional time for sentencing.
Thank you. Mr. Prentice, I can understand your client's request, but at this time, I'm going to deny that. I believe that it would only be respectful to the family to have the opportunity to address the court and be prepared to do so at the time of sentencing. Therefore, that request is denied. I will request that a records check be performed by the 7th Judicial District Department of Correctional Services for the purposes of sentencing. And sentencing in this matter will be set for May 30th at 2 o'clock in the afternoon. Thank you.
Rice Krispies.